Can your ex-spouse still inherit your assets after divorce in Arizona? Usually the answer is no, but there are important exceptions. Under Arizona law, once a divorce is final, your ex-spouse generally is no longer treated as your surviving spouse. That means they usually lose the automatic inheritance rights that a current spouse would otherwise have. Arizona law also has a rule that automatically revokes many estate plan gifts to a former spouse after divorce. So if your old will says, I leave everything to my spouse, and that person is no longer your spouse, Arizona law will usually treat that gift as revoked. The same rule can apply to trusts, powers of attorney, executor appointments, trustee appointments, and similar roles. In many cases, the law treats the ex-spouse as if they had died before you for purposes of that document. Arizona law also addresses property owned with survivorship rights. For example, if divorced spouses owned property as joint tenants with rights of survivorship, the divorce can sever that survivorship interest and turn it into a tenancy in common. There are some key exceptions to this rule. An ex-spouse may still receive assets if a document clearly says they should inherit even after the divorce, if a divorce decree or settlement agreement requires it, or if the parties remarry. Also, some assets, especially retirement plans governed by federal law, life insurance, and beneficiary designated accounts, can create severe complications. If the beneficiary designation was never updated, payment disputes can happen. The final takeaway from all of this is that generally Arizona law says final divorce decrees usually cuts off an ex-spouse's inheritance rights, but do not assume everything is automatically fixed. After divorce, update your will, your trust, your beneficiary designations, real estate titles, retirement accounts, and powers of attorney, because the person listed on the paperwork may still matter, even if the relationship is over after the divorce. Hope this was helpful.